I sat across from my own lawyer expecting a defense. What I got instead was Martin Hale leaning forward across a cold conference table, looking me straight in the eye, and telling me to plead guilty to crimes I had never committed. He said the fraud charges were airtight. He said prosecutors wanted blood. He said if I fought back, I would lose everything. My business, my freedom, and my family. I kept telling him the records were fake, the money trail was planted, and I was completely innocent. He talked over me each time, like my version of events was an embarrassing inconvenience, and all that really mattered now was how quietly I disappeared. His voice never rose. It never shook. He spoke with the calm certainty of a man who already knew how the story ended. I felt my hands go cold on the table. My mouth went dry. Every argument I had rehearsed in my head the night before suddenly felt small against his confidence and the weight of official language surrounding me on all sides. So I signed the plea agreement. My hand barely felt like mine when I did it. And the second my pen lifted from the paper, Martin glanced down at his phone, read something, and the tension in his jaw, tension I had not even noticed was there, simply disappeared. He looked relieved. Not relieved for me. Relieved for himself. That was the moment I stopped asking how I could survive what was happening and started asking one very different question. Who had just been paid to make sure I went down? When I got home that evening, the silence in my house hit harder than anything that had happened inside that conference room. My wife, Dana, looked at me the way you look at someone you are trying desperately to keep trusting, but the words, guilty plea, had already done their damage before I even walked through the door. She had seen the news alert on her phone. My two kids, 7 and 9, could feel that something was terribly wrong even if they could not name it, and they stayed close to each other and away from me in a way that broke something open in my chest. The house was already on the edge of foreclosure. My face had been running on the local news for 2 weeks under headlines that made me sound like a career criminal. I was no longer just fighting charges in a courtroom. I was watching my own family quietly wonder whether the man they had lived with all these years had been lying to them the entire time. That night I could not sleep. I lay in the dark listening to the house breathe around me and kept replaying Martin's face in my mind, specifically that moment when he looked down at his phone and exhaled. I had dismissed it in the room because I was overwhelmed and drowning. But lying there in the dark, with my kids sleeping down the hall and my wife pretending to sleep beside me, I understood it differently. Martin Hale had not looked worried about me that afternoon. He had looked satisfied. And once I saw that, I could not unsee it. Before they destroyed my name, I had spent years building it from nothing. I started my company in Bracken Ridge with almost no capital and a reputation. I earned one honest contract at a time. Nobody handed me anything. Every job I landed came from showing up early, delivering exactly what I promised, and refusing to cut corners even when cutting corners would have been easier and more profitable. That reputation was the whole business. It was the reason clients called me back and the reason new ones found me through word of mouth. But the same honesty that made people trust me also made certain people deeply uncomfortable. I had a habit of looking at numbers carefully, and in Bracken Ridge's development world, there were a lot of numbers that did not want to be looked at carefully. The real trouble started the day I was brought in to review financial approvals tied to the Riverside Harbor redevelopment project, a massive development backed by the city's biggest real estate firm and tied closely to several council members who stood to benefit from it enormously. When I sat down with those invoices, I found duplicate equipment charges, inflated consulting fees, and subcontractor figures that were clearly fictional. I flagged every single one. The room went very quiet. The executives around that table smiled the way people smile when they are deciding whether you are a problem or just an inconvenience. I should have read that silence more carefully. I thought I was rejecting bad numbers. What I was really doing was rejecting the people behind them, and in Bracken Ridge, those people had very long memories. At the formal finance meeting for Riverside Harbor, I laid out everything I had found. Duplicate equipment charges across 3 different invoice sets. Consulting fees paid to firms that had no verifiable work product attached to them. Subcontractor figures that were more than double reasonable market rates for the scope described. I put it all on the table clearly and professionally, because I genuinely believed that was how things were supposed to work. You find a problem, you name it, you fix it. The executives sat across from me with patient smiles and spoke in careful language about complexity and partnership and the importance of not slowing down a project of this scale. They brushed me off the way powerful men brush off people they consider temporarily useful but ultimately replaceable. But I could see it in the way their eyes moved when I cited specific line items. I had touched something real and they knew it. I refused to sign the financial approval. I knew it probably cost me future work on that project and possibly others. But once my signature was attached to numbers I knew were fraudulent, there would be no washing it off. My credibility was the only thing I had built that truly mattered, and I was not going to trade it for a contract. As I gathered my papers and stood to leave, a senior executive named Dern followed me to the door. He shook my hand with a firm, unhurried grip and smiled in a way that did not reach his eyes. He said men who made city projects complicated usually came to regret it. I thanked him and left. A week later, I realized that had not been a warning. It had been a schedule. A few days after that meeting, I went back through my email looking for the thread where I had formally objected to the Harbor invoices, the one with the specific line items I had flagged, time-stamped before the approval deadline. It was gone. Not archived. Not filtered into a folder by accident. Simply not there. My office manager swore the thread had existed because she remembered me forwarding it to her. Our IT vendor blamed a sync error during a routine update and acted like this kind of thing happened all the time. Everyone around me responded to the missing emails with a calm shrug that felt completely wrong given what those emails contained. I stopped trusting luck that day and started saving copies of everything. Documents printed and stored off-site, photographs of screens, notes written by hand in a notebook I kept at home. Then that night, I received an anonymous message sent through my company's general contact form. It was 4 sentences. The last one said, "Stop digging into Harbor if you want to keep your family out of this." I stared at that message for a long time. I did not reply. I screenshotted it and added it to the notebook. But the next morning when I arrived at the office, I noticed small things that had shifted overnight. The way my bookkeeper avoided my eyes, the way a long-term vendor's assistant was suddenly unavailable for calls, the way 2 employees exchanged a look when they thought I was not watching. The people around me had started acting like they already knew something I did not, and the gap between their knowledge and mine was growing by the hour. After that anonymous message, everything around me shifted in ways that were small enough to dismiss individually but impossible to ignore together. A trusted employee of 4 years submitted his resignation by email with no explanation and did not respond to my calls. A vendor I had worked with since the beginning suddenly insisted all communication go through legal, which made no sense for the kind of routine work we did together. My bookkeeper, a careful and steady woman named Petra, started looking at me with an expression I had never seen on her face before, something between guilt and fear, like a person carrying information they were not sure was safe to share. One evening she came to my office after everyone else had gone, set a manila folder on my desk, and told me in a low voice that some records had been changed after hours. Then she walked out without another word. The next morning she called me, and in a completely different tone, said she was not sure what she had been thinking and that everything was fine. I opened the folder she had left. Inside were printouts of altered financial reports, internal documents that had been modified to show fraudulent billing approvals originating from my own login credentials. The timestamps on the alterations were from evenings and weekends when I was not in the building. Someone had gotten inside my company's financial system and built a version of me that had done exactly what I was now being charged with doing. This was not just an accusation anymore. Someone had manufactured the evidence. They had not just accused me of fraud. They had engineered it, piece by piece, and signed my name to it. There was one person I believed could save me before all of this went further, a former Harbor Project employee named Tessa Ward, who had been in the room the day I rejected those invoices. She had watched me push back. She had heard me refuse to sign. I was counting on her as the one witness who could put the real sequence of events on record and prove my objection had happened before any money moved. But when investigators interviewed her, she told a completely different story. She claimed that I had privately told her the invoices were fine and instructed her to stay quiet until the transfers cleared. I could not process what I was hearing. This was not a misremembering. This was not someone confused under pressure. This was a total and deliberate reversal of everything she had witnessed. I tried to reach her through her personal number. It went straight to a voicemail that was full. I sent a message through a mutual contact asking her to call me. She did not. Someone had gotten to her before I could. She now had a lawyer, a new version of events, and apparently a very compelling reason to stick to that version. Then the local news ran a brief piece mentioning that additional witnesses in the Harbor investigation were expected to come forward in the coming days. I sat in my car in a parking lot reading that on my phone and felt the last solid ground beneath my feet starting to crack. I was losing a trial that had not even officially begun. Terrified and running out of options, I hired Martin Hale. In Bracken Ridge, his name was supposed to mean one thing: survival. He was polished, calm, and well-connected throughout the local legal community. His office had the kind of quiet, expensive order that made you feel like you were in the presence of someone who solved problems like this before breakfast. The second I walked in and explained my situation, he spoke with such measured authority that I felt genuine relief for the first time in weeks. The specific relief of handing a crisis to someone who clearly knows how to handle it. He took the case and immediately asked for everything. Every internal file. Every communication record. Every private note about my objections to the Harbor invoices. Every detail of my strategy for pushing back. He was thorough to the point of intensity, and at first I read that as diligence. He was my lawyer. Of course he needed everything. So I handed it over, all of it, because I had nothing to hide and because I believed he was building my defense with every piece I gave him. But there was something about the way he pushed for certain documents, the way he asked follow-up questions about who else knew specific details, that felt less like preparation and more like inventory. Like he was cataloging what existed rather than figuring out how to use it. I told myself I was paranoid. I told myself this was what good lawyers did. But after Martin took over my case, the leaks did not slow down. They accelerated. Once Martin was officially my attorney, the prosecutors started moving with a precision that had no business explanation. They filed motions targeting specific records that Martin had only just finished reviewing. They used language in official briefs that echoed arguments I had floated privately in Martin's office. Not publicly, not in any filing, only in those conversations. A local reporter called me asking about a defense strategy that I had mentioned to Martin as a possibility but had never committed to, and the reporter referenced it as if it were confirmed. I tried to tell myself these were coincidences. Lawyers talk. Information moves in a small city. Legal circles overlap. But coincidences do not repeat themselves with that kind of precision. There is a difference between information leaking slowly through a porous system and information traveling quickly from one specific point to another. The more I watched the prosecution's moves, the clearer that direction became. They were not guessing. They were reading. And the source they were reading from was sitting in my corner pretending to fight for me. The moment that shifted from suspicion to near certainty came during a pretrial status meeting when the lead prosecutor made a passing remark mocking a defense angle that I had only raised once, quietly, tentatively, inside Martin's office. It was a small thing. Just a throwaway comment. But it should have been impossible. That argument had never left that room. And now the prosecutor was treating it like a joke. The leak was not somewhere in the system. It was sitting right next to me, billing me by the hour. The raid on my office happened on a Tuesday morning in broad daylight. There were cameras outside before the agents even arrived, which told me someone had made sure the press knew the timing. I watched through my office window as agents carried boxes of files out to their vehicles while my employees stood frozen in the hallway, not sure whether to speak or disappear. My business accounts were frozen within 24 hours. Payroll failed the following week. Subcontractors I had worked with for years walked off active jobs because they could not afford to wait for money that might never come. The company I had spent years building started dying in front of me, not slowly, not quietly, but in full public view, piece by piece, while the local news filmed it from the street. At home, foreclosure stopped being an abstract threat and became a specific timeline. Dana started making quiet mental lists of what we might be able to sell. The kids picked up on the tension even through the carefully normal routines we were trying to maintain for their sake. Then, sitting alone at my kitchen table one night, I went through the search warrant paperwork line by line and found something that made my stomach turn completely over. The warrant had directed investigators to a specific internal file folder, one that I had mentioned to no one outside my own company except Martin Hale. There was no other path by which that folder name could have appeared on a federal document. That should have been the moment I picked up the phone and fired him. Instead, and this is the thing I still have trouble explaining, I convinced myself there must be another explanation and trusted him even more. When the plea hearing came, everything moved so fast it barely felt real. Martin walked me through what to expect in the car on the way over, the judge's questions, the specific language of the plea, the correct responses, the proper tone. He coached me the way you coach someone through something administrative and inevitable, not the way you counsel someone through the worst moment of their life. In the courtroom, the words came and went around me like a current I could not fight. The judge asked the formal questions. Martin nudged me through each answer with small, firm gestures. And then I heard my own voice say the word, guilty, in a room full of people, and it sounded like it came from somewhere far away, from someone I did not recognize. The media covered it as a clean resolution. Prosecutors exchanged satisfied looks. Martin told me afterward that I should feel grateful, because things could have gone significantly worse. I nodded and said nothing. But walking out of that courtroom and into the gray afternoon light, something cold settled into me, not grief exactly, but clarity. Everyone in that room had wanted this resolved very quickly. The prosecutors, the judge's schedule, my own lawyer. Nobody had wanted it to slow down, to breathe, to allow room for questions. And cases that contain the actual truth rarely move that fast. Guilty men drag their feet. Innocent men get buried under momentum. Standing on the courthouse steps with my life officially on record as something it was not, I began to understand. The plea had never been designed to protect me. It had been designed to seal the truth inside a box and hand me the lock. 3 days after the plea, a young woman I had never seen before approached me in a parking garage near my accountant's office. She moved quickly, kept glancing over her shoulder, and had the look of someone who had rehearsed exactly how long this interaction would take. She pressed a folded photocopy into my hand and walked away before I could ask a single question. I looked down at the document. It appeared to be a calendar entry, printed from an internal scheduling system, showing Martin Hale in a private meeting with executives from Riverside Harbor Development, dated 6 weeks before I had ever officially contacted Martin's firm. My hands were actually shaking as I read it. 6 weeks before I hired him. Before my name was publicly connected to the investigation. Before I had done anything that would logically bring us together. If that calendar entry was genuine, it meant Martin had a pre-existing relationship with the exact group of people who needed me to go down quietly. It meant I had not found my own lawyer. I had walked into one they had ready for me. The document was 1 page. I turned it over and found 4 words written in small, careful handwriting on the back. Check the deleted backup server. I stood alone in that parking garage for a long moment, reading those 8 words front and back, before I understood that this small piece of paper was the first real crack in the wall they had built around me. And if there was a crack, there was a way through. That note led me to Mara Quill. Her name had come up twice in legal circles I had moved through, once as someone who had helped a wrongly convicted contractor get his case reopened, and once in a frustrated remark from a defense attorney who called her the most dangerous paralegal in 3 counties. She worked independently, did not advertise, and came highly recommended by exactly the kind of people who had been on the wrong end of institutional power and survived it. I called her the same night. She listened to everything without interrupting, studied the photocopied calendar page, and told me one thing clearly. Innocence meant absolutely nothing unless I could prove it with evidence that a hostile court could not dismiss, discredit, or ignore. We tracked down an archived server backup from my company's old IT vendor, one that everyone assumed had been wiped during a routine system migration the previous year. The vendor still had it in cold storage. Restoring even a partial fragment took 3 days and significant cost, but when the files came back, so did pieces of email chains that had been deleted from the live system. Those fragments showed invoice records from the Harbor project being modified after the dates I had formally objected to them, alterations made under login credentials that were not mine. My objection had happened first. The fraud had been constructed around it afterward. For the first time since I had said guilty in that courtroom, I had something beyond my own word. I had proof that the lie against me had fingerprints. Mara suggested we attend a civic fundraiser connected to Bracken Ridge's development community, not to confront anyone, not to make ourselves visible, just to watch, listen, and learn the geography of who was talking to whom. I almost said no. Being seen anywhere near harbor-connected executives while I was under a guilty plea felt dangerous. But Mara argued that staying invisible was exactly what they wanted, and that sometimes the most useful intelligence came from watching confident people in rooms where they thought they were safe. We went. For most of the evening we stayed near the edges of the room, nursing drinks, listening to ambient conversations. Nothing notable. I was starting to feel like the whole exercise had been a waste of nerve when one of the senior Riverside Harbor executives, a man named Dern, the same one who had shaken my hand at the door that day, started talking in a small group nearby. He was relaxed, assured, performing the casual authority of a man whose problems were managed. And then, in the middle of some story he was telling, he mentioned a sealed sentencing detail from my case. A specific figure. One that existed only inside the court, in the offices of the prosecution, and in communications between me and my legal representation. There was no version of events where Dern should have known that number. Mara's hand closed lightly around my arm. She had caught it too. We left without drawing attention. Outside in the parking lot, a car I did not recognize was parked directly across from mine and pulled out the same moment we did. Whatever door we had just opened, someone had already noticed us walking toward it. Instead of panicking about the car, Mara decided to use it. She had contacts in the kind of investigative spaces most people do not know exist, and within 48 hours she had traced the vehicle to a licensed private investigator named Buford Cole who operated out of a small office on the east side of Bracken Ridge. His billing records, obtained through sources I chose not to ask about in detail, showed he had been contracted for ongoing surveillance work starting roughly 10 days before my arrest. He had been tracking my movements, logging my meetings, and documenting the routines of my household, including when my children left for school and which route they took. Reading that last part made my jaw go tight in a way I had to consciously control. This was not just legal maneuvering anymore. This was personal, sustained, and deliberate monitoring of my family's daily life. But Mara kept moving. She traced Cole's billing through 2 layers of generic LLC structures before landing on a consulting company called Venfield Advisory Group. On paper, Venfield had nothing to do with Riverside Harbor. It appeared to offer general business strategy services. Its website was vague and its client list was not public. But money had been flowing into it from the Riverside Harbor Development Fund at irregular intervals for nearly 2 years. Venfield was being paid for something. It was clearly not business strategy, which usually meant it was being paid to make problems disappear. When Mara dug deeper into Venfield Advisory Group, the company practically dissolved under inspection. The registered office address turned out to be a shared mail facility. The website had been built using a generic template and had not been updated in over a year. The invoices Venfield submitted to the Harbor Development Fund were full of language so vague it was essentially meaningless. Strategic facilitation, stakeholder alignment coordination, process optimization consulting, while millions of dollars moved through the account attached to them. Mara traced outgoing transfers from Venfield into 3 separate downstream accounts connected to political operatives, city-adjacent fixers, and several individuals whose public income made their lifestyle genuinely difficult to explain. Each connection was 1 layer removed from the Harbor Project, which was exactly the point. But it was the 4th transfer that hit me like something physical. A payment routed from Venfield into a trust account. The trust was registered under a name that meant nothing to me at first, until Mara pulled the trust's formation documents and pointed to the listed beneficiary, a man named Gordon Hale, Martin's brother-in-law. The money trail that began at a fraudulent development project, passed through a shell company, wound through political fixers, and landed inside a trust that fed directly into Martin Hale's family. My suspicion had been slowly building for weeks. Looking at that document in Mara's small office on a Thursday afternoon, it stopped being suspicion and became something far colder and far more definite. This was a pattern. A deliberate, constructed, operational pattern. And I was the loose end it had been designed to bury. That same evening I sat down with Dana and showed her everything Mara and I had uncovered. The calendar page showing Martin's prior meeting with Harbor executives. The restored email fragments showing the alterations to my login. The shell company money trail ending in Gordon Hale's trust. I laid it all out in order as clearly as I could, because I needed her to understand this was not desperate invention from a man looking for excuses. I needed her to see what I saw. She listened without interrupting. She studied each document carefully. When I finished, she sat quietly for what felt like a very long time. Then she looked at me, and her expression was not the one I had been hoping for. It was not relief. It was the face of a woman who had been living with foreclosure notices and frightened children and a husband whose name was associated with fraud, and who understood that half-finished proof and hopeful promises were not going to make any of that stop. She said she wanted to believe me. She said part of her did believe me. But belief would not save the house. Belief would not fix what the kids were absorbing at school every day when other children repeated things they had heard from their parents. She was right, and hearing it said aloud that clearly was harder than I expected. It was not cruelty. It was honesty from someone who had been holding everything together while I chased documents and followed threads. That night she told me to stop telling her I was innocent. She told me it was time to prove it, or stop pretending that proof was coming. Several weeks later, my phone rang from a number I did not recognize. A sequence that looked like a temporary prepaid line. I almost did not pick up. When I did, the voice on the other end was Tessa Ward, the witness who had reversed her testimony against me. She spoke quietly and quickly, the way people speak when they are afraid of being overheard. She said she needed to meet me in person and that it could not wait. We met the following morning at a crowded cafe near the center of Bracken Ridge. Busy enough that no single conversation could stand out, public enough that nothing could happen without witnesses. Tessa looked like someone who had not slept properly in weeks. Her eyes moved constantly. She sat with her back to the wall and kept her hands wrapped around her coffee cup like she needed something to hold onto. She told me she had lied. She said she had been approached separately by investigators and by a consultant she could not fully identify, both of whom told her that I was already finished, that the case was sealed, and that if she did not align her testimony with the approved version of events, she risked being charged alongside me. She had been frightened into it. She was not a corrupt person. She was a frightened one, which is a different thing entirely. Then she glanced across the cafe, and something in her face changed completely. She grabbed her bag, stood up, and walked fast toward the exit before I could say another word. But she left her coffee cup on the table. Sitting beneath it was a small flash drive. I took the flash drive to Mara that same afternoon. She connected it to an isolated laptop, one with no network access, which she used specifically for evidence like this, and we went through the contents together. The drive contained a single audio file, 43 minutes long, recorded in what sounded like a conference room. The audio quality was not perfect, but the conversation was clear enough to follow in its entirety. It was a meeting between at least two people, a consultant speaking in formal, practiced language and a second male voice that was more guarded and brief. They were coaching someone through testimony, walking her through language, through specific phrases, through the precise way to present a false timeline so it sounded like a natural memory rather than an invented one. The consultant's voice was unfamiliar to me. But the second voice, the one that appeared only 4 times in 43 minutes, always in short, complete sentences, had a particular cadence and precision that made me go very still. Mara noticed my expression. She asked me who I thought it was. I said I could not be certain. She said certainty was not what we needed from the audio alone. What the recording proved, regardless of who the voices belonged to, was that a witness coaching operation had been actively running during my case, that Tessa Ward had been managed, that her testimony had been scripted, and that this had been done with inside knowledge of the case. Then, in the final minute of the recording, one of the voices mentioned a counsel packet that needed to be removed before sentencing. That one phrase, spoken almost casually, gave us the next thing we needed to find. The council packet, as Mara explained it, was an internal city document, a set of review materials prepared during the early stages of the Riverside Harbor funding approval process. If it existed and we could find it, it would show the sequence of events around the harbor billing in the period before any money moved. It would show when objections were raised, what those objections said, and who had been informed of them. In short, it could prove that my opposition to the fraudulent invoices was documented before the fraud was completed, which would dismantle the timeline the prosecution had built against me from the ground up. I went through official city records channels first. Staff told me the packet had been lost during a records system migration the previous year. The explanation was delivered with practiced neutrality, as if mislaid government documents were a routine inconvenience rather than a catastrophic failure of public accountability. I pushed through 3 different departments and got 3 variations of the same non-answer. Then Mara found a retired city records officer named Philip Vance who had worked in the archives division for over 2 decades before taking early retirement. He met us for coffee. He was careful with his words but honest in his meaning. He said documents like that council packet did not vanish accidentally when powerful people's interests were attached to them. He said they got buried, misfiled, reclassified, or physically relocated until the people who needed them could no longer find them in time. Then he told us the physical archive copies were stored in the basement of the City Records building on Millbank Street. 2 days later, that basement flooded. The flooding was reported as a burst pipe, a maintenance failure in an aging building, the kind of thing that happens in older city infrastructure. Mar did not believe a word of it. She called a contact at the building and found out the flooding had been contained to the archives section specifically, while the rest of the basement remained dry. She drove to Millbank Street while city attorneys were still coordinating the response, and she talked her way inside by presenting herself calmly and professionally and simply not stopping when people suggested she wait. By the time anyone thought to formally block her access, she had already reached the partially flooded room. Most of the archive boxes were damaged beyond usable condition, but not all of them. Working quickly, Mara pulled several folders from a damaged cabinet on the upper shelf where the water had not fully reached. She laid the pages out carefully on a dry table in the hallway and photographed everything before the paper could deteriorate further. Later, drying and reconstructing what she had recovered, we found what we had gone looking for. The salvaged pages contained council member communications from the early harbor approval period, and several of them referenced a formal objection submitted before funds were released, an objection that matched my records exactly. But the piece that changed everything was a routing slip attached to one of the memos. It showed the warning packet had been forwarded to a legal liaison. That liaison's name appeared in Mara's notes from earlier in our investigation. He had previously worked as a contractor in Martin Hale's old consulting practice. Martin had not just represented me poorly. He had been connected to this from the very beginning. With what we had gathered, the recovered emails, the shell company transfers, the routing slip, the audio recording from the flash drive, Mara filed an emergency motion requesting a narrow pre-sentencing hearing to review whether fraud had been committed on the court itself. It was not a full exoneration. It was not even close to that. It was a crack in the door, a technical mechanism designed to allow a court to look at itself when the integrity of a proceeding is genuinely in question. The judge granted it reluctantly. The hearing was set for 3 weeks out. Martin showed up to the preliminary session looking exactly as I remembered him from every stage of my case, polished, composed, and radiating the kind of professional confidence that made it very easy to mistake control for innocence. He framed me as a convicted man thrashing desperately against the consequences of his own choices, too guilty to accept what he had already admitted in open court. He was smooth and he was convincing, and for a moment, sitting in that room and watching the machinery of official procedure grind forward, I felt the same suffocating certainty I had felt on plea day, that the system was going to consume the truth the same way it had the first time. Then the prosecution filed their response brief. And Mara pointed to a paragraph near the bottom of the document, one that quoted language from our private strategy notes in near-identical phrasing. Martin was still feeding them. Even now, supposedly no longer active in my representation, he was still passing information across the line. Mara laid it out in a document that took her 2 full days to construct. A side-by-side comparison of the prosecution's language against the internal strategy notes, with metadata timestamps showing when each document had been created and accessed. The correspondence was not approximate. It was not a matter of shared legal vocabulary or overlapping logic. The prosecution brief contains specific phrase constructions, specific argumentative sequences, and specific admissions of strategic limitation that existed in only one place before they appeared in that brief, in notes prepared after Martin had ceased formal representation but while he still had access to certain communications through me. He had not just betrayed me to get the plea. He had maintained an active pipeline of information after the plea, ensuring that my attempts to climb back out of the conviction would be consistently undermined by the people who needed me to stay buried. I was still absorbing the full scope of this when a package arrived at our house, delivered by hand, no return address. Inside was a single sheet of paper with 2 photographs of my children at their school, printed clearly enough to show their faces and the school entrance sign behind them. Below the photographs was a typed sentence telling me to withdraw the emergency motion or the consequences would become personal. I went very still reading that. I thought about what Dana had said weeks earlier about desperate people making mistakes. Whoever sent this had just made one. Because threatening a man's children does not break him. It removes every remaining hesitation about how far he is willing to go. I brought the threat to the police that same day. The response was cautious and slow in a way that told me plainly that this investigation touched names and connections the department was not eager to antagonize. I filed the report anyway and made sure Mara documented every step of my interaction with the responding officers. Dana had seen the photos before I reached the police, and something in her shifted the moment she did. The quiet, restrained woman who had been holding our household together through 2 months of collapse stopped holding back and started fighting alongside me in a way I had not seen before. She said anyone willing to photograph children to protect themselves was not powerful, they were cornered. And cornered people made errors. She was right immediately. Mara pulled the threat document and had its paper stock and printing characteristics analyzed. The toner pattern and paper weight matched a specific printer model, and cross-referencing purchase records from commercial print shops in Bracken Ridge led us to a copy shop on the north end of town. That shop's transaction records, obtained through a contact Mara would not name, showed a regular account belonging to a political consulting firm that had been publicly associated with the campaign of a council member named Holt who sat on the committee that had approved the Riverside Harbor funding. For the first time in this entire ordeal, the thread led somewhere visible. Someone with a name and a public face had just handed us the connection we needed. And they had done it because they were afraid. A week before the emergency hearing, Mara received an encrypted message through a secure communication channel she maintained for sensitive sources. The sender identified himself as a financial consultant who had worked with Venfield Advisory Group, the shell company we had traced Martin's brother-in-law's trust back to. He said he wanted to talk. We arranged a meeting through a mutual intermediary and met him in a location Mara chose, not him. He was a mid-level professional. Not a mastermind, not a villain in the traditional sense, just a person who had been well paid to move numbers through systems in ways that left minimal trace. He had helped route money from the Harbor Development Fund through Venfield and into the downstream accounts attached to political operatives and fixers. He had done it because the compensation was exceptional and because he had convinced himself it was technical work, not moral work. Then my guilty plea happened. And instead of the arrangement ending cleanly the way he had been promised, the people above him started preparing to reassign blame. He had begun receiving subtle signals that if anything unraveled publicly, his role would be the one that surfaced first. Martin's name, he told us, was in the original design of the payment structure, not as a passive recipient, but as a directing voice in how the money moved and where it went. He had documentation. Account records, internal transfer notes, email fragments from the construction phase of the scheme. He gave us everything. He gave it to us because Martin Hale had apparently decided that this consultant would be the most useful person to sacrifice if the whole thing fell apart, and that man had found out. The forensic specialist Mara brought in to examine the digital evidence was a woman named Dr. Ines Foley, who had testified in over 60 fraud cases and who approached evidence with the kind of methodical patience that made her genuinely difficult to discredit. She spent 4 days with the approval records from the Harbor Project, the digital trail that prosecutors had used to place my login on fraudulent invoice approvals. What she found at the center of the case against me was precise, technical, and devastating to the story that had been built around my name. The timestamp proving I had approved the fraudulent invoices had been inserted into the system using a backdated administrative override. The override did not come from my login. It came from a maintenance-level credential that had been issued to a third-party IT vendor contracted by the Riverside Harbor Development Group. My actual login had no record of accessing those invoice files on the dates in question. The approval that was supposed to prove my guilt had been executed by someone using a vendor credential on a date I was not in the system, placed there after the fact to complete the manufactured evidence trail. Dr. Foley produced a 30-page technical report documenting every layer of the manipulation, with timestamps, metadata records, and access logs that formed an airtight sequence. She was clear about what the evidence showed and equally clear about what it did not show, any legitimate connection between me and the fraudulent approvals. The same night her report was finalized, someone left a message with her professional answering service calling her credentials into question and suggesting her involvement in the case might damage her reputation. She forwarded the message to Mara and submitted her report anyway. The emergency hearing opened on a cold morning in late November. Martin arrived unhurried, his expression carrying the same polished authority he had performed throughout my case. Prosecutors leaned hard on procedure. I had entered a guilty plea voluntarily, in open court, and courts do not overturn confessions simply because defendants later regret them. It was a strong argument, and for the first few minutes it felt like it might be enough. Then Mara began presenting the evidence in sequence. She moved through it the way an engineer dismantles a failed structure, methodically, without drama, showing each piece in relation to the others until the overall shape became impossible to ignore. The restored email fragments. The Ventfield payment trail ending in Gordon Hale's trust. The routing slip from the salvaged counsel packet connecting Martin to the Harbor legal network before my arrest. Dr. Foley's forensic report on the backdated override. The flash drive audio proving witness coaching. The financial consultant's documentation mapping the original money structure. Taken individually, each piece was significant. Laid out in sequence, they stopped looking like a defense argument and started looking like a map of a deliberate, coordinated operation designed to manufacture a conviction and bury the people who had committed the actual crime. The room went quiet in the way rooms go quiet when something genuinely real is happening. Then the judge looked at Martin and asked him one question that he had clearly not prepared for. The judge asked Martin to explain, under oath, his relationship with Ventfield Advisory Group prior to his engagement as my defense counsel. The question landed like a stone dropping into still water. Martin's composure did not shatter, but it bent. For the first time in any proceeding I had watched him navigate, he paused before answering. Not a practiced pause. The pause of someone calculating. Before he could respond fully, the courtroom door opened and Tessa Ward walked in. She had made her decision. Under oath, she described in clear detail exactly what had been done to her testimony, who approached her, what they threatened, and the specific inside legal information they used to convince her my fate was sealed. She named the consultant from the audio recording. Her account aligned precisely with the flash drive. Mara played the audio for the court. Martin denied the second voice was his. The financial consultant, called forward from the gallery, identified the meeting, the people present, and the Ventfield payment connected to the witness preparation, naming Martin as the person who had directed that payment. The story being told by the evidence had grown so much larger than the story that had originally put me in this position that the original narrative could no longer hold its shape. When the judge ordered an immediate misconduct inquiry into Martin Hale's conduct throughout my entire case, I looked across the room at Martin's face. His expression had settled into something I recognized from memory. Exactly the way I had looked on plea day, standing in that courthouse corridor with my life officially recorded as something it had never been. Once the misconduct inquiry formally opened, The architecture of the conspiracy began collapsing inward under its own weight. Developer Dern publicly distanced himself from Venfield Advisory Group within 48 hours, attributing his company's association with it to decisions made by staff members he had not personally supervised. The consultants connected to Venfield shifted blame toward the city officials who had directed the funding approvals. Council member Holt, whose political consulting firm had been connected to the threatening letters sent to my home, retained separate counsel and issued a statement characterizing his relationship with the harbor project as strictly procedural. Everyone was suddenly a bystander. Everyone was suddenly surprised. The prosecutors, facing the full technical report from Dr. Foley and the financial documentation from the consultant, filed a motion to vacate my guilty plea on the grounds that newly surfaced evidence indicated the original conviction had been obtained through fabricated evidence and corrupted legal representation. The confession they had used to close the case, the same guilty plea Martin had steered me toward in that cold conference room, was now being treated by the same prosecution office as evidence of how deep the manipulation had reached. Martin attempted to defend himself using procedural technicalities. His argument was that attorney-client communications, even if they had been shared, could not be the basis for criminal charges without establishing clear intent to harm. Mara had anticipated every version of this argument. A final metadata comparison prepared by Dr. Foley proved that Martin had actively accessed and transmitted protected case documents during the period he was supposedly no longer involved in my representation. The hearing ended with my name cleared and Martin's career in ruins. But Mara told me quietly afterward that one piece was still missing. Months after the hearing ended, the foreclosure was stopped. Dana and I sat at our kitchen table one evening and let ourselves breathe properly for what felt like the first time in over a year. The kids came home talking about ordinary things, homework, friends, a movie they wanted to see, and I sat listening with the specific kind of gratitude that is difficult to describe to anyone who has not spent 12 months watching their family live inside a crisis they could not fix. Martin Hale was professionally finished. The state bar had suspended his license pending misconduct proceedings. Multiple civil suits had been filed against him by former clients who began reviewing their own cases after the inquiry became public. The man who had told me in a calm voice to plead guilty to lies had become Bracken Ridge's most cited cautionary tale. I received a civil settlement from the developers and shell company operators, enough to rebuild what they had nearly destroyed and then some. When Dana joked that this was probably the first time a lawyer had helped us by losing, we laughed harder than I had laughed in longer than I could clearly recall. The kids finally stopped asking why Daddy was on TV. That was worth more than any settlement. Never hand your fate to someone just because they carry a briefcase and bill by the hour. Sometimes the best defense is turning their own rules against them and watching the suit get tailored right out of the courtroom. But Mara's call about that one missing name in the payment records? That's a story for another day. Because today, justice finally wore the right suit.